Hello everyone, my name is Robert Greenstein, a partner at Greenstein and Milbauer, the attorneys behind 1-800-VICTIM-2. And welcome back to the 1-800-VICTIM-2 studio. Today I'm going to talk about the steps of litigation. We feel it's important that our clients understand the process so that they feel more comfortable throughout the process. So very briefly, in order to start a lawsuit in New York, you file a document called a summons and complaint. A summons gives the defendant notice that they're being sued, and the complaint sets forth the allegations that the plaintiff will be required to prove. After the summons and complaint is filed with the court, we have 120 days to serve it on the defendant or defendants, and we use a process server to do that. After defendants are served, they then have 30 days to file a document called an answer. An answer is pretty much a document where the defendants will admit or deny the allegations in the complaint. Usually this deny all of the allegations, but that's just a part of the process. In their answer, or I should say filed with their answer, is usually a demand for a document called the Bill of Particulars. And the Bill of Particulars is pretty much, the name describes what it is. It's basically a list of questions so that the defendant gets the particulars of the accident. In other words, they're asking for specifics regarding the claim. So when we get that demand for Bill of Particulars, the ball then is in our court to prepare a Bill of Particulars. So some of the typical questions that need to be answered in the Bill of Particulars will be the date and time of accident, the location of the accident, pretty much, the acts of negligence that we're alleging, maybe some laws were violated to set forth the laws that were violated, the specific injuries that we're claiming, the medical treatment that our client had, the providers that treated the client, the disability that the client had. Maybe the client couldn't get out of bed for a period of time, or maybe the client couldn't leave the home for a period of time. Maybe the person couldn't work for a period of time. So these are all things that are set forth in the Bill of Particulars. Again, it's just really providing the particulars of the claim. After we provide the Bill of Particulars, we usually then will file a document with the court requesting a conference. The first conference is called the preliminary conference. And the goal of the preliminary conference is to sit in front of a judge and to formulate a timeline for each party to do certain things in what's called the discovery process. Discovery is that each side gets to learn about the strengths and weaknesses of the other side's case. So we want the judge to set forth a timeline that certain things need to be done. This prevents the defendants from dragging their feet and delaying the case. The judge will sign the preliminary conference and it becomes an order, which is a court-ordered document. One of the most important parts of the preliminary conference is scheduling the client's examination before trial, commonly referred to as an EBT. It's a deposition where basically the defendants get to ask the plaintiff questions about the accident and the injuries and everything that the plaintiff is claiming. Likewise, we get to ask the defendants questions about the accident. And that's how we're going to be able to prove their negligence. After we have the examination before trial, the defendants are then entitled to have the plaintiff examined by one of their doctors. When a plaintiff puts their medical condition in issue, in other words, they're saying they're hurt, the defendants are entitled to have that plaintiff examined by one of their doctors so their doctors can try to verify the injuries, or more specifically, their doctors are going to try to dispute the severity of the injuries, but they are entitled to have the plaintiff examined by one of their doctors. After that physical examination is done, well, then the case is ready to be placed on the trial calendar, and we do that by filing a document called a notice of issue. Now, just because a case is placed on the trial calendar doesn't necessarily mean that the case is going to go to trial. I've just explained the litigation process, but anywhere along this any one of those steps, a case can settle. In fact, some cases settle even before a lawsuit is commenced. And just because a case is placed on the trial calendar doesn't necessarily mean that the case is going to trial. When the case is on the trial calendar, there'll be many conferences called pre-trial conferences where the court will bring the parties together and try to get a settlement. And it may not happen in the first conference, it may not happen at the second conference, but there'll be multiple conferences while the case is on the trial calendar in an effort to bring the parties closer together to resolve the case. Most people don't want to go to trial, and the courts certainly don't want the parties to go to trial. They want the parties to work out their disputes. So these pretrial conferences are really a great place for cases to get settled, assuming they haven't been settled earlier in the process. So I very briefly have explained the litigation process. Again, we want our clients to feel comfortable with the process, but really the most important thing to stress is that just because you're in litigation doesn't mean that the case can't get settled. We understand that most clients would like their case to be resolved sooner rather than later, but sometimes by pushing the litigation, it puts us in the strongest position to effectuate that settlement. As our motto goes, don't be a victim twice. If you're in an accident, give us a call, 1-800-842-8462. Call 1-800-VICTIM2. Thank you.